grew out of the long-standing efforts of Christian fundamentalists to reassert the scientific vitality of the Bible narrative of creation against its Darwinist rival. The great landmark in this Bible science conflict was the famous Scopes case, the monkey trial of the 1920s, which most Americans know in the legendary version portrayed in the play and movie Inherit the Wind. The legend tells of religious fanatics who invade a school classroom to persecute an inoffensive science teacher, and of a heroic defense lawyer who symbolizes reason itself in its endless battle against superstition. As with many legendary incidents, the historical record is more complex. The Tennessee legislature had passed, as a symbolic measure, a statute prohibiting the teaching of evolution, which the governor signed only with the explicit understanding that the ban would not be enforced. Opponents of the law, and some people who just wanted to put Dayton, Tennessee on the map, engineered a test case. A former substitute teacher named Scopes, who wasn't sure whether he'd ever actually taught evolution, volunteered to be the defendant. The case became a media circus because of the colorful attorneys involved. William Jennings Bryan, three-time Democratic presidential candidate and Secretary of State under President Woodrow Wilson, led the prosecution. Bryan was a Bible believer, but not an uncompromising literalist, in that he thought that the days of Genesis referred not to 24-hour periods, but to historical ages of indefinite duration. He opposed Darwinism largely because he thought that its acceptance had encouraged the ethic of ruthless competition that underlay such evils as German militarism and robber baron capitalism. The Scopes defense team was led by the famous criminal lawyer and agnostic lecturer, Clarence Darrow. Darrow maneuvered Bryan into taking the stand as an expert witness on the Bible and humiliated him in a devastating cross-examination. Having achieved his main purpose, Darrow admitted that his client had violated the statute and invited the jury to convict. The trial thus ended in a conviction and a nominal fine of $100. On appeal, the Tennessee Supreme Court threw out the fine on a technicality, but held the statute constitutional. From a legal standpoint, the outcome was inconclusive, but as presented to the world by the sarcastic journalist H.L. Mencken, and later by Broadway and Hollywood, the monkey trial was a public relations triumph for Darwinism. The scientific establishment was not exactly covering itself with glory at the time, however. Although he did not appear at the trial, the principal spokesman for evolution during the 1920s was Henry Fairfield Osborn, director of the American Museum of Natural History. Osborn relied heavily upon the notorious Piltdown Man fossil, now known to be a fraud, and he was delighted to confirm the discovery of a supposedly pre-human fossil tooth by the paleontologist Harold Cook in Bryan's home state of Nebraska. Thereafter, Osborn prominently featured Nebraska Man, scientific designation Hesperopithecus Harold Cookii, in his anti-fundamentalist newspaper articles and radio broadcasts, until the tooth was discovered to be from a peccary, a kind of pig. If Osborn had been cross-examined by a lawyer as clever as Clarence Darrow, and satirized by a columnist as ruthless as H.L. Mencken, he would have looked as silly as Bryan. The anti-evolution statutes of the 1920s were not enforced, but textbook publishers tended to say as little as possible about evolution to avoid controversy. The Supreme Court eventually held the statutes unconstitutional in 1968, but by then the fundamentalists had changed their objective. Creation research institutes were founded, and books began to appear which attacked the orthodox interpretation of the scientific evidence, and argued that the geological and fossil record could be harmonized with the biblical account. None of this literature was taken seriously by the scientific establishment or the mass media, but the creation scientists themselves became increasingly confident that they had a scientific case to make. They also began to see that it was possible to turn the principles of liberal constitutional law to their advantage.